Members are attending in person in the room, and as far as I understand, we have no one online. So I'd like to make a few comments for the benefit of the members beforehand. First of all, since no one's online and we don't have to spend any time on that, would like to inform all the members that today is Ms. McPherson's birthday. Happy birthday, Ms. McPherson. So on a less happy note, if I may, I'd like to ask all the members that they wait until I recognize them by name before they speak. Unless it's Heather, of course. She has all rights today. So a reminder that all comments should be made through the chair. Now, pursuant to the order of reference of Monday, February 13th, 2023, the committee commences consideration of Bill S-8, an act to amend the Immigration and Refugee Protection Act to make consequential amendments to other acts and to amend the Immigration and Refugee Protection Regulations. Concerning the drafting of any amendments that may be proposed by the members, I would like to highlight and remind everyone that members should contact Alexandra Shora, the Legislative Counsel, as soon as possible, should they intend to introduce any amendments. Now, it's my great honor to welcome the sponsor of this bill to our committee. It's a great honor to have the Honorable Minister Marco Mendicino here with us. So we look very much forward to his opening comments. However, before doing so, I just wanted to thank all the officials who are accompanying him today. From Canada Border Services Agency, we have Ms. Kelly Acton, the Vice President, Strategic Policy Branch. We have Mr. Brett Bush, the Executive Director of the Immigration and Asylum Policy Innovation Branch. From the Department of Citizenship and Immigration itself, we have Simon Fredette, the Director of Migration Control and Horizontal Policy Division, and Mr. David Chan, Acting Director, Asylum Policy, Performance, and Governance Division. From the Department of Foreign Affairs, Trade and Development itself, we have Mr. Stephen Burridge, the Director of Sanctions Policy and Operations Coordination. And finally, from the Department of Public Safety and Emergency Preparedness, we have Mr. Sebastian Overton Giguère, the Assistant Deputy Minister, National and Cyber Security Branch. So all of that being out of the way, thank you for appearing here today, Minister, for your opening remarks. You have 5 minutes.
Thank you very much, Mr. Chair, as well for the introductions of the officials who are joining me. Bonjour, Monsieur le Président.
Good morning, Mr. Chair, members of the committee. Thank you for inviting me to speak to the objectives of Bill S-8. Canada will never be a refuge for bad actors. The amendments proposed in C-8 will address the current shortcomings within our sanctions framework. For things to be perfectly clear, by aligning the Immigration and Refugee Protection Act and the Special Economic Measures Act
are clear and will ensure that all foreign nationals subject to any sanctions under the Special Economic Measures Act, or what we refer to as CEMA, will also be inadmissible to Canada pursuant to the Immigration and Refugee Protection Act. Bill S-8 will modernize Canada's sanctions inadmissibility framework. From a border integrity perspective, the amendments proposed by Bill S-8 are the best way to ensure that a sanctioned person would be deemed inadmissible to Canada. Since February 24th, 2022, when Russia launched its brutal war against Ukraine through its latest illegal incursion, the government of Canada responded with numerous packages of new sanctions targeting many Russian and Belarusian individuals and entities. As of March 1st Over 1,500 individuals have been sanctioned under the CIMA in relation to this conflict. This is in addition to the more than 1,000 other foreign nationals sanctioned under CIMA who are tied to other countries and or regimes such as Myanmar, Syria, and most recently Iran, following the so-called morality police's brutal human rights violations, just to name a few. While some of these individuals are currently inadmissible to Canada, the majority are not. Si un ressortissant étranger sanctionné se présente,
Should a sanctioned foreign national arrive at a Canadian border, Bill S8 will ensure that a CBSA officer can immediately make a finding of inadmissibility and can remove the person from Canada.
will mean that the roughly 2,500 individuals currently sanctioned under CIMA for grounds not linked to IRPA would be inadmissible to Canada. As the IRPA is currently written, its inadmissibility provisions do not align with the basis for imposing the majority of CIMA sanctions issued against Russia, and that is precisely what S8 seeks to remedy. Ces amendements s'appliqueront au-delà de la situation.
These amendments will apply beyond the situation currently underway in Russia and Iran. They will be in a position to act against other organizations such as Al-Qaeda and ISIL.
Will also strengthen Canada's ability to identify and stop sanctioned foreign nationals before they travel to Canada. Simply put, there are currently no parallel existing grounds of inadmissibility, which is why the legislative amendments as proposed in Bill S8 are so crucial. They will ensure that the Government of Canada's sanctions framework remains cohesive, enforceable, and responsive. The bill will provide Canada with much-needed authorities to hold bad actors to account and to contribute to concerted action with our international allies. It will provide a clear and strong message that the Government of Canada's comprehensive sanctions framework has meaningful consequences, not only from an economic perspective, but from an immigration and access to Canada perspective as well. Merci de votre temps.
Thank you for your time, Mr. Chair. I'd be happy to answer any further questions you may have.
Thank you very much, Minister. We will now open the floor to questions from the members. We first have MP Genis. MP Genis, for this round, everyone has been provided 6 minutes. The floor is yours.
Thank you, Chair. Thank you, Minister. You're going to be using, I assume, information from CSIS when you make sanctions inadmissibility determinations. Does CSIS intelligence contribute to decisions about who gets sanctioned under CIMA or is otherwise deemed inadmissible?
I would say they are one of a number of agencies that contribute to the analysis, which is undertaken by Global Affairs prior to listing under CIMA.
Thank you for that answer. How often are you briefed directly by CSIS?
I'm briefly, I beg your pardon, routinely, certainly at least once a week and often more frequently than that.
Okay, so you receive direct briefings from CSIS once a week or more often?
That's correct.
Okay. My understanding as well is that CSIS often communicates through written products, through intelligence assessments. Do you read intelligence assessments as well, separately from those briefings?
Yes, and it's not always supported by written assessments, but yes, I do see written assessments, intelligence assessments.
Okay. Do you read all intelligence assessments that would come into your department?
I certainly get summaries of intelligence assessments, and then that is supplemented by verbal and other briefings from CSIS officials.
Okay. So who receives the full intelligence assessments, and who's responsible for summarizing or you deciding what information to bring to your attention or not bring to your attention?
My deputy minister and chief of staff are the two most principal advisors to me who help to prioritize exactly what it is that is put before me in terms of intelligence.
Okay. Would your chief of staff and your deputy minister read all intelligence assessments then?
I'm fairly confident that yes, between the two of them, as well as the staff that are in their offices, are able to get access to those reports and then help to prioritize what gets put before me.
Yeah, just to put a fine point on to make sure I'm understanding right, because I'm sure they're able to get access to them. But if an intelligence assessment is sent to your department, can you say that yes, the deputy minister and the chief of staff reads them, or one of them reads them, or would they be reading a summary that somebody else prepared for them?
I think often it's both. So in other words, they will get both the complete report as well as a summary. And sometimes they, from the reading of the report, will prepare summaries, which then directly come to me.
Okay, but your expectation is that both of them would receive and read the intelligence reports,
and that they are delivered. Yes, that's correct.
Okay. Have you given CSIS direction in terms of what issues they should or should not brief you on? Anytime X, Y, or Z comes up, I want to know about it directly, or have you given that kind of direction to CSIS?
Yes.
Okay. Will those making recommendations about sanctions or inadmissibility, will they always receive those intelligence assessments? Like, is that one of the things that, because as minister, you will make those determinations around sanctions. Will you directly review intelligence assessments related to those sanctions?
Can you just clarify your question, Mr. Genus? What information are you asking about to support which decision?
Decisions around sanctions, because this is related to the bill. If somebody brings, if you're making a determination about a sanction, would you ask CSIS to provide you with the intelligence assessment directly, or would you rely on summaries in that case?
I may rely on summaries, and if I've got additional questions about the source information which went into the summary, including the original intelligence report, I will certainly ask questions. Yes.
Okay, thank you. One primary area in which we've seen motivation for sanctions is sanctions against individuals or entities that are involved in foreign interference activities here in Canada. So in relation to that, I want to ask you if in 2021 there was information in an intelligence assessment about Canadian MPs being targeted by the PRC. Was that information in any intelligence assessments in 2021?
Well, as you know, I very much appreciate your question. I have to be guided by the law under the Security of Information Act in terms of what I can and cannot disclose. There are strict constraints on that, but we have created forums in which we can declassify that information or allow parliamentarians and or officials to have access to that information so that it can be discussed with Canadians. And I would cite public reports that have come from NSICOP and CIRA in which we are able to navigate those types of questions.
Okay. If an intelligence assessment contained information, you've said it would your expectation would be that it would be read by the chief of staff and the deputy minister.
Point of order, Mr. Chair. We're here on S8 today. I'm just wanting to make sure that we're getting evidence that relates to S8 in terms of this committee, so we can advance our understanding and even propose amendments around the legislation. I'm just trying to listen for how this actually pertains to S8 specifically, and I would ask the members through you to focus their questions on S8.
Mr. Zuberi, I'd like to remind every member that we should try to focus our questions on the issue at hand, which is S8. Mr. Genus, we did stop the clock. You still have a minute and 12 seconds remaining.
Thank you, Chair. If information in relation to individuals involved in foreign interference, potentially who should be sanctioned as a result of that foreign interference, if that had been an intelligence assessment in 2021, your expectation is that the chief of staff as well as the deputy minister would have seen it and that you would have been provided with a summary of that information. Is that correct?
Well, let me just clarify, because I think you're referring to the recent events involving your colleague, Mr. Chong. You heard the Prime Minister indicate that there is a new directive that has been issued to CSIS to ensure that if there are allegations or reports around foreign interference that involve parliamentarians, that come directly to the attention of the Prime Minister as well as myself. And I assure you and all of the colleagues here that we will adhere to that directive.
But prior directive, you still think the deputy minister and the chief of staff would have seen that information, correct?
Well, I think, look, it's a very important question that you're asking. I think it's also important to remind members of this committee that CSIS and other intelligence agencies make determinations and judgment calls on what intelligence is actionable.
It's a question that deserves an answer, though. Would the chief of staff or the deputy have seen it? Okay, thank you, Chair.
Thank you, Mr. Jennings. We next go to MP Zuberi. You have 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair, and thank you, Minister, for being here today.
And team for being here. I'll pick up on the line that was really touched upon by my colleague from colleague opposite. And first off, before doing so, I'd like to just acknowledge that I respect immensely the work you're doing to protect Canada. You and other ministers are doing to protect Canada from foreign interference and to protect our democracy. That being said, I'd like to lean into the questions around foreign interference and ask how will S8 in particular help to protect our country from foreign interference?
Through you, Mr. Chair, to my colleague, Mr. Zuberi, first, thank you for the question. Thank you for your advocacy as well on matters especially pertaining to human rights and for standing against authoritarian dictatorships who are oppressive. I want to just take a moment to express my gratitude to you. I would also say that in addition to the bill that is before you that will help to align the work that our colleagues at Global Affairs do in listing individuals under CIMA to the Immigration and Refugee Protection Act, that there are existing authorities that do deal with, for example, espionage. And by virtue of those authorities under the Immigration and Refugee Protection Act, an individual can be deemed inadmissible if there are grounds to believe that they have committed an act in relationship to espionage. But what this bill will do is it will further close any existing loopholes if, for example, there are specific individuals who have been listed under the Special Economic Measures Act, or CIMA, and align that in express language under IRPA so that they are deemed inadmissible, but only after an analysis has been undertaken by Global Affairs.
So this will help to further protect Canada from foreign interference, this important legislation.
Absolutely.
We work in partnership, Canada works in partnership with many countries, Five Eyes, G7, other countries. And I'd like you to just elaborate a bit upon how S8 contributes to what other countries are doing in this domain. Can you speak about how other countries are addressing the issue that S8 puts forth and how that fits in within the schema?
Well, I will defer to officials who have undertaken an analysis of exactly what kind of legislative or statutory schemes are in place among our democratic allies, but I believe that S8 will generally align with the approaches that have been taken by like-minded countries. The point is to make sure that there is not a disconnect, that if an individual has been named under CIMA because they are facilitating the transgression of human rights or are in some way supporting financially or otherwise the acts of an authoritarian regime, like, for example, in Russia, as it continues its illegal incursion and war in Ukraine, that individual then becomes inadmissible to Canada by operation of statute, and that statute is IRPA.
So this legislation touches individuals. It also touches entities in terms of exclusion. Not exclusion, in terms of the sanctions regime, touches not only individuals but also entities. Is there any impact on shareholders of entities that might be sanctioned when it comes to S8? or legislation, the broader legislation?
Again, through you, Mr. Chair, to Mr. Zuberi, I will defer to officials exactly on what their impact analysis is with regards to potential impacts on shareholders. But I do want to clarify, because you used the word specifically, that entity is not in the bill, and that is for good reason. We believe that we have crafted language which is precise and clear, and allows us to focus on individuals who have been named under CIMA, and that is the best way to align the objectives of CIMA with IRPA.
And lastly, in the next minute, we, Canada, have been a steadfast ally of Ukraine, as many other countries have been. And you touched upon how this legislation, in terms of the sanctions regime, have actually helped in our efforts when it comes to Ukraine. Do you want to elaborate a bit more upon that in the time that remains, in the 45 seconds that remains, about how S8 will further our solidarity with Ukraine and check Russia's aggression?
It will ensure that the individuals that have been listed under CIMA, who are in some way supporting Russia's illegal war in Ukraine, are deemed inadmissible. And that is just the latest measure that we can take to support Ukraine. I would point out that we have been with the people of Ukraine since February of 2022, March of 2022, through a variety of initiatives, militarily, diplomatically, by creating immigration pathways to help those who've been displaced, and equally through the work that we are doing in my portfolio by, among other things, sending the RCMP to ensure that those who are committing war crimes and other transgressions against human rights are held to account. And we will continue to be there for the people of Ukraine and Ukraine to ensure its sovereignty.
Merci.
We next go to MP Bergeron. You have 6 minutes, sir.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you so much, Minister, for being here with us. Thank you to all of your colleagues, the officials. Can you start by asking us why you started with delivering this bill before the Senate to start? Really, it was for technical reasons. It had to do with the process that the government used. I mean, it's an option. There are many things that we needed to do in the House of Commons. So sometimes we go through the Senate to advance other priorities like this one, to make sure that we can achieve the end that we all want, which is to close loopholes, to align the work under CIMA with IRPA. In sections 5 and 6, there's a definition of inadmissibility as including sanctions. What does that mean exactly? What does sanctions actually mean? As for a technical analysis, I would defer to my colleagues, the officials here. But in a practical sense, the analysis under CIMA examines matters that have to do with corruption, other activities which are illegal pursuant to international conventions. And if there are records of or evidence that satisfies those tests, then that is regulated under CIMA. The purpose of this bill, S8, is to align the work under CIMA with what's done within IRPA, so that person is inadmissible. I know you couldn't have been aware of this, but the committee intends to do a study on the Canadian sanctions regime, and certainly we have the feeling, the group that will be looking at the sanctions regime, it seems as though you're putting the cart before the horse in a way, because the legislative process forces us to go with the bill first, then we might as well go ahead. You might have heard of some concerns raised by the refugee groups that a person who is persecuted in their home country could be denied in terms of an asylum claim, even if they haven't done anything reprehensible themselves because of what might have happened in their country of origin. What would you do with that? Answer, well, that's a good question. We'll certainly be working with organizations that represent refugees and asylum seekers. Our government has a strong record on our priorities. We have one of the, perhaps the strongest asylum claim regime in the world. But to answer your question, we will have trust in our officials at Global Affairs for them to do analyses that are based on fact. Afterwards, if they meet the test, when this bill enters into force, that will mean that a person may or may not be admissible. If there are individuals where you can't satisfy that test, then the bill will not be triggered. What's in the bill will not be triggered. To be clear, Minister, are you saying that regardless of what the bill actually says, an asylum seeker coming from a sanctioned country could still have his or her claim looked at? I would say that each case is based on its own merits. The register under CIMA, and by extension what's happening in this bill, well, prior to all that, there's an assessment of all the facts, and that would look at all of the circumstances affecting an individual in the context of an analysis done by the department. The Canadian Bar Association proposes the following measure: that modifications or amendments be made to the Immigration and Refugee Protection Act, establishing a distinct grounds for admissibility for sanctions with respect to an entity, a person, or that would do away with the reference to country, which it finds is too broad, given the concern that I've just mentioned, concern of these refugee communities. What do you think of this Canadian Bar Association notice? Of course, the refugees' rights need to be protected. You have to protect people who are really in a vulnerable category. The purpose of this bill is precise. It is aligned with CIMA, and I hope that you have trust in the officials that are doing the analyses prior to someone being registered under CIMA. I think, in brief, there are checks and balances. There are parameters in line to look at all of the circumstances, even if there are current concerns with respect to the rights of refugees within the analysis prior to concluding the CIMA process. That is one way for us to protect the rights of individuals and to make sure that this bill aligns with the exercise under CIMA.
We now go to Madam McPherson. You have
Thanks.
6 minutes.
Thank you, Mr. Chair. Thank you all for being here today and answering our questions on S8. I'm very grateful for you taking on sanctions. I think it's very important for us to strengthen our sanction regime. As Mr. Bergeron mentioned, we are going to be undertaking a study. That was a study that I had brought forward for us to look at. One of my big concerns with our sanction regime, of course, is the enforcement of the sanction regime, because it's very easy to put people's name on a list. It's not always very easy to make sure that those sanctions are being enforced. With regards to S8, though, I do have a few questions. So Minister, you've heard me be a little bit critical before when the sector, when experts are not consulted. We might get to C41 later on today. I have something I'd like to ask for my birthday, Mr. Minister.
to give you a present. We'll see.
So with regards to S8, though, the legal experts, the refugee sector have said that there do need to be amendments to this bill. They have called for that. I think Mr. Bergeron referred to the use of the word sanctions. So we have heard from the Bellamissa Law Group, from the Refugee Center, that they've both raised concerns about the lack of clarity with regards to language on sanctions in this bill. And of course, we have the study that we will be looking at this. Why is it so vague? How do we make sure that that's better? Would you be willing to accept amendments on that with regards to that?
I'll say a few words off the top, and then I would encourage you to hear what Mr. Bush has to say, because I want to be responsive. But as I was saying to your colleague, Mr. Bergeron, that prior to the operation of this statute, there would be a rigorous examination of all of the facts under CIMA that could look at all of the facts and circumstances before a conclusion is rendered on as whether or not that individual is listed. I appreciate that that if I understand your question correctly, Ms. McPherson, it's that we want to make sure that this statute is not vague or overbroad. I think those are laudable objectives. I would encourage you to...
And current concerns that the Canadian Bar Association has brought forward with regards to this legislation as well.
And we want to make sure that they are sufficiently focused and constrained, but perhaps Mr. Bush might be able to say something specifically.
Thank you. So we in fact did meet with the Canadian Bar Association about these concerns and had several discussions, but the short answer would be this. The sanctions regime is managed by our colleagues at Global Affairs. We did not agree with the suggestion that we should be importing language from the sanctions into IRPA, because it is not the place to assess the sanction. The place to assess the sanction is with our colleagues at Global Affairs. We also don't agree with the Canadian Bar Association in the context of the various mechanisms for seeking redress to the sanction. There, in fact, and my colleague at Global Affairs could speak about this, there are measures for seeking redress to the sanction. The measures in IRPA that the minister has been speaking about are simply to ensure that the people who have been sanctioned by the government are now inadmissible, as you in fact mentioned a few moments ago. The last point that I would mention, and I just lost my train of thought, and I'm sorry.
Two out of three is not bad. So I want to make this clear. So
Or official from GAC as well. Did you want to add anything to that?
Sure, maybe just on the point around redress for sanctions. So there is the ability for a listed individual or entity to apply to the Minister of Foreign Affairs to be delisted from sanctions. That decision does rest with the Minister of Foreign Affairs on whether or not an individual is delisted from our sanctions regime. Further to that, they also do have recourse to have the listing itself or the decision on the delisting application brought before court and judicially reviewed.
So I guess one of my concerns, of course, is always that there will be consequences, unintended consequences that folks that shouldn't be on these, that shouldn't be suffering punitive actions will suffer. I think that is again what we saw in C-41 when we weaponized international development instead of preventing terrorism from being funded. So my concern, of course, is that what we're looking at right now is if somebody wants to appeal, doesn't agree with this decision, shouldn't be on this list, shouldn't be added, they have to come to you, then they go to Minister Joly, they get all of these things clarified, and is that mechanism actually going to work? Because you will know that the business of government is not a quick situation. No intended.
Yeah,
directly to you.
Well, I appreciate that clarification, Ms. McPherson. There are available avenues of relief to the federal court, which provides judicial oversight in the exercise of the functions under CIMA as well as under IRPA, which again will now function as a two turnkey system to ensure an admissibility. But I just come back to the central premise of your question, which is what are we doing to safeguard against the potential of inadvertent overreach here, and especially with regards to vulnerable individuals who may wish to claim status as either an asylum seeker or as a refugee. And I am confident that this new bill will not in any way diminish from the existing pathways to protect those rights where they exist under IRPA and the law.
So the refugee sector is not as confident as you are, Minister. So will you be open to amendments to this legislation?
As you've heard me say many times before, Ms. McPherson, I'm always prepared to work with you and this committee and other parliamentarians if we think that there is a realistic and practical way in which to either provide clarification on the existing language or to strengthen it. I will keep an open mind about that.
Thank you.
We now go to the second round. For the second round, each member is provided 4 minutes. Mr. Jennis, you're up next.
Thank you, Chair. Minister, you had strong words for CSIS on the weekend. I want to ask, do you have confidence in CSIS, and do you blame CSIS for the fact that Mr. Chong was not informed about a threat against his family 2
Point
years
of order,
ago?
Mr. Chair, on relevance, given our stated agenda for this meeting being the consideration of Bill S8, and I would just like you to consider that. Thank you.
Chair, can I respond to the point of order?
Yes.
Yeah,
Mr.
Chair. Chair, I think the minister's confidence or lack thereof in CSIS is critically important given that part of S8 is responding to assessments that are made by our security agencies.
Thank you, Mr. Jennis. I'd just like to urge all members to keep it within the ambit of the bill before us. Mr. Jennis, please proceed.
Thank you, Chair. Minister, you heard the question. Would you like to answer it or not?
No, I'm quite content to answer it, and I appreciate again why you're asking these questions, despite the fact that we're here principally to talk about Bill S8. But of course, I've got confidence in CSIS. I mean, these are individuals who work to protect our national security every day, and I also would point out that your question used language like blaming. The only people that I think that we need to be united in holding accountable are the hostile actors who are attempting to undermine our democratic institutions. Mr. Genus.
Thanks, Mr. I could just jump in there. I think there's probably agreement that something went wrong 2 years ago, though. And if you think blame is too strong a word, fair enough. But who carries this error? Who do you think carries this error in that someone was not informed about a threat against their family? Was the error made by CSIS? Was the error made by the minister? Was the error made by the chief of staff? Who made the error?
I think we have to be constantly vigilant to make sure that our internal governance, including directives around what gets briefed directly in person to ministers who are responsible, including and up to the Prime Minister, reflect the state of the landscape when it comes to foreign interference. And Mr. Genus, you put a lot of time into studying this subject matter. I think you would acknowledge that threat landscape has evolved significantly in the last few years alone, and it's probably evolving just about every day. So making sure that our directives align to those realities is important to ensure accountability.
Thank you, Minister. I'm going to move on, although I don't know that I fully got the response there. At the end of my last round, I had asked you specifically if your chief of staff or deputy would have seen the 2021 intelligence report on foreign interference. Could you clarify? Did the minister or the chief of staff see that report?
Well, again, only because you put the question directly and personally to me. I was not in this portfolio in July of 2021 when the report was alleged to have been, has been reported in public. But again, we are making sure that our directives do reflect the landscape as it exists today, so that if there are reports that touch on parliamentarians, MPs, and the like involving foreign interference, that they will now come directly to me and the Prime Minister.
Okay, so I guess the answer is you don't know if the deputy or the chief of staff read the report. But you said it's general practice for the deputy or the chief of staff to read these reports. But in the particular case, you're saying you weren't the minister, so you don't know. Is that
point of order? Just back to my first point of order. In terms of the relevance to S8, I'm trying to understand how this will help our committee study with respect to S8. I don't yet see that. I'm not sure, Mr. Chair, if the questions should be more focused around S8 or like, are we just talking about what's in the news today?
Remind all the members to remain focused on S8 and to make their questions relevant to the bill at hand. Mr. Jennings.
Thank you, Chair. Thank you. In my final minute, I want to pick up on something you said, Minister. So it's the matter we're dealing with at hand, which is on the directive that you have issued to bring foreign interference targeting elected officials to your attention. Does that apply to provincial and municipal elected officials as well, or just parliamentarians?
I would certainly start by prioritizing the members of Parliament with whom we work with in the House of Commons. But I also want to assure you, Mr. Ginnis, that we're looking at other levels of government. In fact, CSIS has provided
just specifically in terms
briefings.
of the directive, because I'm almost out of time. Does the directive cover provincial and municipal elected officials?
We will ensure that we are briefed directly on parliamentarians and will make additional refinements as may be needed. Okay. But I think this is important. CSIS has briefed other levels of government at their request, most recently.
Right. But it's a question of what information is coming to you and the Prime Minister, because it seems to me that if an everyday citizen is facing the threat of foreign interference, that should be treated with an extreme level of seriousness.
Point of order.
I agree.
I think that's my time.
Again,
Thanks.
The S8 relates to amendments around sanctions. I'm not sure how this will help us to understand those amendments around, or not amendments, but legislation that puts gold on top of sanctions.
Minister, because we're out of time.
Mr. Chair, as you can see, I'm trying to be as responsive as I possibly can. I think we are moving a bit afield of the four corners of the bill that we are here to debate. But I want to be transparent with Mr. Ginnis and all of you. Look. We take the issue very seriously. We're being upfront. We're putting in place with the tools that are necessary to ensure the safety and security of all parliamentarians. And this is going to be the ongoing work that I hope we can do across the aisle.
Thank you, Minister. Next, go to Dr. Fry. Dr. Fry, you have 4 minutes.
Thank you very much, Chair. And thank you, Minister, for coming and answering all the questions that you asked and trying to be transparent with regard to those questions. I think that's very important. I just wanted to go back to what the Canadian Bar Association said. They felt that the concept, which included country, made it too broad. How are you going to deal with the idea that everyone coming, take Russia, for instance. I mean, we're clear about who we're sanctioning in Russia. Question is the Duma, the whole Duma sanctioned in Russia? And what about individuals and the country? Just because you're a Russian living in Russia, does that mean you're sanctioned? I think that's something that people really want to know because it's broad. I think that was a question from the Bar Association. The other question I want is to ask is refugee claimants who are from a sanctioned regime have that ability to come and seek individual admissibility as a refugee. Who is going to look after that? How is that going to be investigated? You said on a case-by-case basis, but where is the buck going to stop in terms of that investigation?
Through the chair to you, Ms. Fry, I would say I appreciate both questions. I think they're related. So in the first instance, the operation of the bill that is before you, once it is in force, will only be triggered after an analysis has been undertaken by Global Affairs with regards to the listing of an individual under the Special Economic Measures Act, or CEMA. That analysis, as I understand it, within the expertise in the domain of Global Affairs, focuses on gross human rights violations, focuses on corruption. And those judgment calls are made on the basis of the facts that are before them. So they will look at whether or not the individual has been in some way affiliated with a hostile actor, an authoritarian regime that is perpetrating those bad acts, or those gross human rights violations, that corruption. They will be entitled to look at the entirety of the record before them. If they are satisfied that the threshold is met under that statute, then that will automatically trigger the inadmissibility under the new provision, which we are proposing under Section 8 under the Immigration Refugee Protection Act. And the point is to ensure that Canada is not a safe haven for any individual who may be trying to prop up an authoritarian regime.
No, I wanted to ask about the question of entity. I think my colleague, Mr. Zuberi, asked that question with regard to entity. If someone inadvertently, is a member or stakeholder, a stockholder or whatever in an entity, how do you define entity? Because entity is not fully defined in this bill. How do we define that clearly?
I believe that that's an important question, as I mentioned to our colleague, Mr. Zuberi, that word is not used in Bill S8. That was a conscious decision so that we don't in any way conflate or confuse the analysis, which is focused principally on the individual first and foremost, that is before global affairs, for analysis under CIMA.
I know, but the question is, unless you define entity clearly in the bill, how are people going to understand what you mean when somebody owns shares in a company that is carrying on the acts and didn't know about it? How is that definition going to be used? I think that's the clarity that people are seeking a little bit.
Yeah.
So people don't get inadvertently caught.
And again, Mr. Chair, through you to Ms. Fry, perhaps Mr. Burridge from Global Affairs might be able to shed some additional light, because the analysis really does fall within the remit of GAC. And I would invite Mr. Burridge to add a few words about this.
Thank you, Mr. Chair. Maybe what I would say is that individuals and entities are listed very specifically under CIMA. So the sanctions themselves apply to the specific individuals or entities that are listed. In this way, there's a dealings prohibition that is put on Canadians and preventing them from being able to deal or to transact with those specific individuals or entities. So that said, when we were talking about inadmissibility, the inadmissibility would apply to those individuals and entities that are listed under CIMA. Shareholders, for instance, may or may not be listed individually. So the inadmissibility only applies to those that are actually listed under CIMA.
Thank you. That clarifies that greatly. How much time do I have, Chair?
Out of
That's it?
time? Yes.
Thank you.
So we next go to Mr. Bergeron. You have 2 minutes, Mr. Bergeron.
Merci, monsieur.
Thank you, Mr. Chair. In the context of the second reading debate of S8, you received the report from our committee about an effective and efficient framework for our sanctions regime, honoring the memory of Sergei Magnitsky and going further than that. And you were referring to the Immigration and Refugee Protection Act being amended to designate all individuals sanctioned under the Special Economic Measures Act as admissible to Canada. You said that it was the most effective and most efficient way of determining who was inadmissible to Canada in the travel process, so that that person would not be able to access a visa to come to the country. You were a Minister of Immigration. Why did you wait more than 5 years before going ahead with this bill? Why wait for the war in Ukraine before finally proceeding to the implementation of the recommendation made by this very committee and reformulated in 2017?
D'abord, en tant que
First off, as former Minister of Immigration, we accomplished a great deal. During the pandemic, we reorganized the immigration system to welcome a record number of immigrants. In my view, this has been good for the creation of jobs, it's been good for the economy, and it's also been good to protect Canada's record when it comes to refugees and vulnerable persons. As you already asked me in the previous question, now we're dealing with a bill that will strengthen the authorities that already exist today to reassure everyone that Canada will never be a safe haven for anyone who supports in any way authoritarian regimes.
Two minutes is very fast. I guess going back to one of the concerns that I was raising earlier about the impact on those that may inadvertently be on the list incorrectly or may disagree with that assessment. You've outlined that there are processes to do that with, that there are processes for people to get redress or to get an appeal, but yet those things cost an awful lot of money and they take an awful lot of time. In fact, my team, who are remarkable, have explained that it can cost thousands of dollars. We know refugees don't have thousands of dollars. How will you mitigate this risk?
Look, I think it's an entirely important question to make sure that we respond to. I will say that there have been some modifications, and Ms. McPherson, if you will allow me to clarify one of the answers that I provided earlier, and my officials will expand on that there are some references to the use of the word entity. This is a key change to the project of law, which is before the committee, and it ensures that sanctions against a non-state actor like an ISIS or a Taliban or Al Qaeda are inadmissible. So I just wanted to make sure that I put that clarification on the record.
But so the answer to that, this could cost thousands of dollars that refugees won't have, so they won't actually have access to justice, to access to the systems that you've put in place to protect them. Your answer is?
Well, our answer is that, in fact, I know my colleague, the Minister of Justice, has put in place additional legal aid supports to ensure that those who are seeking asylum or seeking to make a refugee claim are able to get access to legal aid services to navigate the system. I know as well that working closely with organizations that do advocate for refugees like Carl, with whom we have close relations, that we are putting clear information on our websites to make sure that they can navigate those processes.
So the access is through legal aid, and it has been, just to clarify, it has been increased so that it can accommodate some of the needs?
We are endeavoring to make sure that there are legal aid services
So it
that are
hasn't
in
been
place.
increased to accommodate the need.
IRCC has put in place some additional, is working hard, I beg your pardon, to ensure that we address those challenges.
Thank you. We now go to Mr. Jennings. You have 4 minutes.
Thank you, Chair. I do want to underline that the use of intelligence assessments from CSIS is very important for our discussion of sanctions. It's one of the key, I assume, actually, as the Minister said at the beginning, it's
Mr.
one
Chair,
of the key
point
sort
of
of
order. Could I just
evidentiary inputs.
clarify the rounds and how this is happening? I thought the Minister was here for 1 hour.
Yes, we still have 2 questions remaining.
2 rounds or 2
2
questions?
4-minute slots.
Okay,
Yes,
thank you.
Shall I resume?
Please,
Okay.
Mr.
Thank
Jennings.
you. Thank you, Chair. So in that vein, for information used by the Immigration Department that will be involved in the determinations about inadmissibility, I assume that when intelligence assessments are done by CSIS, they go to some point person in the Immigration Department. Is that correct?
If there are inadmissibility concerns, then those intelligence reports will be shared with the appropriate departments, yes.
Okay. And then it's up to the point person in immigration to share with those within the department that need to see it. When you were immigration minister, who in your office would have received this kinds of intelligence information? Would it have been you directly, your chief of staff, your deputy minister, somebody else?
You know, as a matter of general procedure, Mr. Jennings, it would depend very much on the significance of the case. Obviously, there are many, many cases which are dealt with and addressed by our delegated authorities, so not all of them would come up directly to my attention. So it would depend very much on the individual particulars of each case.
Okay, but someone must have been responsible for receiving the intelligence assessments and deciding who needed to see it and who didn't see it. So at what level would that person have been?
It'll depend on, again, the particulars of the case, but this is where we get back to questions around internal governance. Ultimately, a minister will depend on their chief of staff and their deputy minister to help prioritize that information flow.
Okay, so in your current role at public safety, aside from your chief of staff, which other positions held by political exempt staff in your office receive access to intelligence assessments?
Point of order, I'm trying to again understand how this relates to S8 and the new legislation on.
You'll see.
What is the difference between these words and not defining?
I don't see any relevance whatsoever. So if I could just remind you once again to remain within the ambit of Bill S8.
Further to that point of order, Mr. Chair, it's not only relevant, it's also a parliamentary tradition in that a minister has responsibility when they are the minister, and it is not normal by any stretch of the imagination under parliament tradition to be asking ministers about their previous job, because there is a minister of immigration now who has that responsibility. Thank
Okay,
you.
just Chair, on the same point, I've actually moved past that point for better or worse. So sure, yeah.
Let's just try to keep this relevant, Mr. Jennison.
Thank you, Chair. I did ask a question, so out of respect for the minister, just is he interested in answering the question, given the
Point of
questions on the
order,
record?
Mr. Chair. I
Just
thought
trying
you
to-
already spoke about this question and this line of questioning.
Yeah,
and
I'm
we're
trying to
seeming
extend the
get
courtesy to the
ex-
minister. if you know, if he's-
I believe
It's not,
we're still getting the exact same question being reformatted when you already expressed yourself as chair on the matter.
Mr. Jennison.
Thank you, Chair. I appreciate that there may be some disagreements about the issue of relevance. The point I made at the beginning was that use of intelligence assessments is critical for sanctions, and the minister made that point himself. So I'm curious about who sees intelligence assessments, because those are the inputs for decisions about sanctions.
On that point of order,
yeah.
Mr. Chair, point of
Can-
order.
Can we
The reality is, as the minister has explained, the actual functioning of the sanctions, both on who is sanctioned and how they are delisted from sanctions, is not the responsibility of this minister. It's the responsibility of the Minister of Foreign Affairs. This activity is about stopping people who are sanctioned from getting into Canada, which has been a call from all
That's the point
opposition
of debate.
parties, as well as the government parties, to ensure that our sanctions regime is robust enough to make sure that people are inadmissible.
Mr. Jennings, please do bear in mind that we're trying to remain focused on Bill S8. You have a minute and 54 seconds remaining.
Minister, out of courtesy for you, having asked the question, I wonder if you're interested in answering it or not. If you'd like to address it.
Point of
for it.
order, I don't know how many times you as chair need to repeat yourself for us to actually get it in our heads about this line of questioning.
Can I
It's-
not
it's-
offer the courtesy to
it's
the minister to respond? To
you know,
what's
it's
already on the public
unbelievable.
record?
Mr.
Unbelievable.
Jennings, please, you've been warned several times.
Mr. Chair, I think the question I'm asking is relevant. It's about intelligence assessments that can then be used for sanctions.
This is the fourth
So
time.
my
This is
question,
Mr. Barry,
Point
please.
of order.
yeah.
Sorry.
Look, Minister, do you have any comment you want to make one way or the other on the foregoing discussion?
Mr. Jennings, I've been, I think, pretty forthright in answering the question that you posed now a few times.
Okay, I don't agree, but the public will judge, I suppose. Is there anybody in your office that you can say 100% of the time reads the intelligence assessments that come through?
I believe you asked that question on a couple of occasions earlier in this hour, and you have my answers on that.
Could you repeat it? Is there anyone in your office who you can say with certainty reads 100% of the intelligence assessments that come through?
Yes, I explained that the combination of the officials that work within the deputy minister's office and my ministerial office will take a look at those reports and then prioritize what gets sent to me, either directly through the report or through a summary or through a verbal briefing.
Okay, so who is the exempt staffer that you can say reads 100% of the intelligence assessments?
Mr. Chair, again, I've answered these questions, and
I
will
think you said your
continue
chief
to
of
be
staff. Is that correct? Does your chief of staff sees every single one?
Yes,
Okay.
very
All right.
specifically, Mr.
Thank you.
Jennings, you've asked those questions now on numerous occasions. I think you're attempting to portray that I'm being evasive.
No.
I'm not. I've been very forthright. I said the deputy minister and the chief of staff are principally responsible in the prioritization of intelligence that comes before my eyes. That's very clearly on the record now numerous times.
And they read
Point
every
of
single
order,
one.
Mr. Chair. The whole line of questioning
I'm out of
from
time anyways.
Mr. Jennings has been focused on anything but S8. I haven't heard a single, maybe there might be one or two in the record, but almost all of them have nothing to do with S8.
And we go to MP Sarai. You have 4 minutes.
Thank you, Minister, for coming. My question is, this piece of legislation, S8, combined with SEMA, combined with the Mendicino Act kind of tighten the legislation to make it a criminal offense for contravening or failing to comply with sanctions, which in all three cases I think is a hybrid offense, allowing violators to be charged with either a summary conviction or an inadmissible offense. I want to know, would the department's stance be to deport such a person if they're in Canada or charge them? We also don't want Canada to be a safe haven where you can go and try there, and if you don't, the worst case, you just go back. If they have contravened any of these acts, would that be, in your purview as a public safety minister, something that they should be charged for, or would be the de facto that they be sent back?
Mr. Chair, it's an important question, and yes, if someone is deemed inadmissible under the Immigration Refugee Protection Act, that we can then, by consequence, commence deportation proceedings to remove them.
But if they've contravened an act and we can charge them here in Canada, would we pursue charges against them here? Because sometimes in that case, that might be a win-win for them to be able to just go back and not be charged when they've actually committed an offense, and in that country will not charge them.
Yeah. I think it's important to point out that certainly as it relates to proceedings for removals, including any other administrative proceedings, that we allow for due process to take its course. I beg your pardon. There are important procedural rights that any individual who faces stark consequences, including removal and or detention, are entitled to. And what this bill will do is ensure that there is due process prior to the invocation of the amendment under S8, and that due process exists on the front end under the analysis that is undertaken by Global Affairs Canada. And then on the back end, if the individual who has been listed under CIMA and is therefore inadmissible under IRPA does always have the option to seek judicial review before the federal court.
The other question I have is more to do with inadvertent overreach. A lot of times we as constituent MPs get cases of people when they're young, part of activist movements. That activist movement, they might have just went to a rally or participated in a town hall or some sort of a little protest, and then eventually they're considered labeled with that, even though they had no violent actions or whatnot. Are there protective measures to make sure there isn't inadvertent overreach for people that were just involved in a rally or whatnot, but never were part of any criminal activity?
Mr. Chair, I believe there are sufficient checks and balances through the due process that the individual is afforded by the analysis that is undertaken by Global Affairs. And certainly thereafter, if there's any question about how that discretion was exercised by officials, and then under IRPA, that they can seek judicial review before a federal court. But I would point out that these individual cases are taken very seriously by Global Affairs, that listing somebody under CIMA is not a trivial thing, that attention is care to examining the facts on the merits. And that is because we recognize what's at stake for those individuals. Being rendered inadmissible is a serious, serious thing. And so therefore, we have put in place the appropriate checks and balances into the process prior to sanctioning an individual under CIMA, and by extension, rendering them inadmissible once this provision becomes law.
And will groups have the
Mr.
ability?
Sarai, I'm afraid you're out of time.
Sorry, thank you, Minister.
So at this point, it being almost 10 after 12, I wanted to thank you, Minister. You were very, very generous with your time. And also, I should say that some of the questions did not appear to be relevant in the least bit to me, but you were incredibly forthcoming in responding to those as well. So thank you for appearing before our committee. Very grateful. We will
Thank you, Mr.
now suspend very, very briefly for a minute or two, just to allow the minister to leave and the officials to take over.